Good morning, everybody. It's a pleasure to be here during a really difficult period for the economy, which obviously was the spur for this legislation. I will give an overview of what the legislation covers, particularly the insolvency measures, but I'll try and talk a little bit more about some of the policy reasons behind it. And then afterwards, I'll talk a little bit about what I think happens next now that the act has been, now that the bill has become an act and that the tools are in place. First of all, a little bit of an overview of the legislation and why we felt there was a need for it. Clearly, the government had started its work to respond to the coronavirus pandemic by putting in place fiscal measures that were there for immediate support of businesses through literally loans and money, both to individuals and to businesses. But it was recognised very early on that that in itself would not be enough, and that further regulatory and legislative changes would be needed. And it was the Secretary of State's announcement on the 20th of March that announced that this bill and measures would be brought forward to change insolvency law as one of the principal responses. There were, of course, others, such as the Coronavirus Act, but and I'll talk a little bit about that and how that interacts with these measures as well a bit later. But at that point, the Secretary of State announced that there will be a package of permanent measures to insolvency law, which was the corporate restructuring package, and that there would also be some temporary suspensions of insolvency law. And then there were further announcements later in April in relation to statutory demands and winding up petitions. I'll go into all of those a bit more detail a bit later, but essentially what we have is an act that is in two parts. One that brings forward permanent changes to insolvency law, which is the addition of a corporate restructuring package, and some temporary changes to insolvency law, which are essentially relaxations of insolvency law that are there to deal with certain aspects of the pandemic for a temporary period only. And I'll deal with each of those separately. And finally, there are also some temporary changes to company law, which again are temporary easements of certain regulatory requirements in relation to filings at Companies House and the need to have physical annual general meetings. I'll move on in my slides to the temporary measures. And as most of us will know, the corporate restructuring package is very similar to the Chapter 11 bankruptcy procedure, which is found in the United States and some other jurisdictions around the world. And what the EU will implement itself in the corporate restructuring directive by the end of next year. And like most restructuring packages, it has three elements to it: a moratorium, termination clauses, and a restructuring plan. The moratorium is simply what it says on the tin. It's there to give companies a period of breathing space whereby their creditors can't legally enforce their debts whilst the company seeks some form of rescue procedure. There are, of course, a number of protections in the moratorium, considering that this does infringe significantly on creditors' rights. The principal element of the moratorium is that it gives a 20-day breathing space for against creditor action. That can be extended by a further 20 days by the company, but any extensions beyond that period must be agreed either by creditors or a court. Significantly, and what's different with this moratorium to other moratoriums that are already in the insolvency framework is that the company's directors remain in control during the moratorium, but the moratorium is overseen by a new role, which is called the monitor, who must be a licensed insolvency practitioner. And the monitor has rules which it must follow. Next slide, please. Key features of the so that's the moratorium. Moving on to the termination clauses. The second part of the restructuring package is literally that. Most of us will understand that many supply contracts have a termination clause should a company enter into an insolvency procedure. This, from a policy aspect, makes rescue of a company very difficult, particularly if they're key supplies. And therefore, this particular measure brings in a temporary suspension of the ability of a company to terminate supply, where it's based solely upon the company entering into a insolvency procedure. It's not just for the moratorium, it applies to other insolvency procedures that are already in the Insolvency Act. Naturally, as there are a number of requirements on companies and it impinges on their rights, there are a number of protections within this new measure. The first being that suppliers can apply to a court to be exempt from the requirement if they feel that this brings significant hardship to them, such as threatens their own insolvency. And we brought in a temporary exemption for small companies during the COVID-19 period, recognizing the difficulties that this brings to those in particular. If we could move on to the next slide. The final part of the corporate restructuring package is the new restructuring plan. This is quite a new and novel tool for the insolvency framework, in that whilst it's designed to operate in the same way that schemes of arrangements operate under Part 26 of the Companies Act, and indeed this new plan has been inserted into the Companies Act as Part 26A, it does have one significant additional difference, which is that it introduces cross-class cram down, which essentially means that dissenting classes of creditors can be bound to the plan. But the important protection here is that any dissenting class cannot be made worse off than they would be in the most likely alternative procedure should there not have been a restructuring plan. In other words, if you're bound to a plan that you voted against, you can't be made off any worse than if, for example, the company had gone into administration or liquidation. But finally, and perhaps the most important protection, is that all plans must be sanctioned by the court as fair and equitable. We don't expect restructuring plans to be used by smaller companies. It's most likely to be used by larger companies that have much more complex debt arrangements, such as involving bonds, and we wouldn't expect the legal cost of such a plan to be particularly cheap. But that's the last part of the restructuring corporate restructuring package. What I should have also mentioned is that although this is a temporary, a permanent addition to insolvency law, there are some temporary measures included in there. The first is the one I've already mentioned in relation to small companies being exempt from the termination clauses. But in the moratorium, there are two essential criteria to enter into a moratorium. The first is that the company is or likely to be insolvent, and the second is that the company is likely to be rescued. The second of that, likely to be rescued, we recognise that that's a particularly difficult judgment for company directors and insolvency practitioners to make during this period. So we have relaxed that particular requirement during the COVID-19 period only. Those temporary relaxations will last until the 30th of September, and I'll explain the significance of that date once I get on to the next set of measures. The next three measures, sorry, you've gone one slide too quickly. Could you go back one slide, please? The next three set of measures are the temporary changes that have been made to insolvency law to deal with specific issues relating to the pandemic. The first is a temporary suspension of statutory demands and a significant restriction on winding up petitions. We recognise that this is a significant intervention in the normal workings of the Insolvency Act, but the policy behind that was that the government had already passed the Coronavirus Act 2020, which introduced a significant prohibition on commercial landlords from evicting their commercial tenants from their tenancies based on the fact that they couldn't pay their rent because of the lockdown. It was quite unfortunate. Whilst most landlords were complying with that, there were significant reports soon after that of many landlords issuing statutory demands to use another form of an insolvency procedure or another form of debt collection to go after their debts. And there were reports of one weekend of significant hundreds of statutory demands about to be served. And therefore the government decided to act, and it announced that it would temporarily void all statutory demands that have been placed between the 1st of March and well, it was the 30th of June, but it was extended during the passage of the bill to the 30th of September, and that winding up petitions would be severely restricted in that the petitioner would have to satisfy a court that the debts that were being petitioned for were not COVID-19 related. It's recognised that that's a very high bar, but that was the policy aim, was to ensure that forbearance was delivered. Moving on to the last of the temporary measures, which is the move on to the next slide, please, which is the temporary suspension of wrongful trading. This was announced at the same time that the Secretary of State made his announcement on the 20th of March. It was quite clear that the onset of the pandemic and the lockdown of the economy, many company directors were seeking urgent advice from their legal advisors as to whether or not wrongful trading would severely bite on them, and that they would need to think about whether they should continue to try and trade despite being trading insolvently. The government didn't want that to happen, particularly to companies that were otherwise perfectly viable, and therefore the decision was made to temporarily suspend wrongful trading. In other words, to remove the deterrent effect on directors, to give them the legal comfort that they needed in order to continue to use their best efforts to trade during this difficult period. And that essentially means that directors can't be made liable if the company's made worse off as a result of their continuing to trade during a specific period, and that period is the 1st of March to the 30th of September. But all other checks and duties do remain on directors, such as the compensation orders and the disqualification regime, as well as directors' duties. I think that finishes my slides, but I think it's worth me just talking generally about a little bit about the Parliamentary Passage and what happens now. First of all, we wanted to make sure that when the bill became an act, that it was ready to go quite almost immediately. And I think we've managed to do that in a number of ways. First of all, normally you would have, when you bring in an act of this size, you would then take a few months afterwards in order to get certain orders made where certain exclusions or rules needed to be made. But in this case, we put them all into the Act immediately. And in particular, the monitor's rules to operate the moratorium are in the Act, but they are temporary rules, just so that there are rules to allow the monitor to act immediately. But we will be drafting more fuller rules, which we hope to have in place perhaps later this year or early next year. In addition, we've produced guidance for the monitor, and this has also been published as well. Of course, there are a number of interactions with the court, and all the requirements for filings or hearings. The court has now produced new court practice directions, which have all been published and have all been sent to IPs as well. In addition, the filings that are needed to be made at Companies House, these are all up and ready, and Companies House can accept these immediately. So it was important for us to ensure that the Act was ready and the tools were ready to be used now, particularly as the economy begins to come out of lockdown. The temporary measures are currently to the 30th of September. They were initially, when the bill started, at the 30th of June, but as the bill did not get royal assent until the 1st of till the end of June, sorry, it was clear that we needed to make an amendment to extend that further, and that's what we've done to the 30th of September. Whether or not we will extend the rules, or sorry, the temporary measures even further, and we are considering this, is not a decision that is likely to be made in relation to insolvency alone, because the government has made a number of decisions across certain regulatory frameworks, which includes the landlord's measure, but also the fiscal measures, and any decisions made will be consistent across the piece. So there is significant work ongoing within government now as to whether or not those measures should be extended, and if so, for how long. And that includes the fiscal measures as well. And then finally, I guess there were a number of other things that happened during the bill, a number of amendments that were made, particularly during the passage of the Lords. One was to take out super priority, which was not a policy intention, and I won't say any more on that, just in case there is some Q&A during the Q&A period. And also that we have re-extended the power to allow for the regulation of prepacks. That's been extended for a further year, and it's likely that we'll bring forward regulations at some point during that period. But then finally, I think what's very important for the next 6 to 18 months is the monitoring of how these new tools are working, to make sure that they are working, and so that we can respond very quickly should we need to be able to make changes should any part of the Act or the tools not be working as we had intended that they should be. It's quite a feat to have been able to legislate and do the drafting in 6 weeks and then get it through Parliament in 6 weeks, but that's never the best way to implement such complicated and complex new legislation. You normally need to take a bit of time to get it right to ensure that there are no unintended consequences. As a result, we do expect some unintended consequences, and we hope that the market will tell us when they find these things for themselves if we haven't, so that we can make those changes ourselves quite quickly. We have the necessary powers should we need to do so. Caroline, I think that probably brings me to a reasonable close to allow for questions. How does that work?
Thank you, Paul. Yeah, that was a really good run through of all the key measures that you've we have got quite a few questions from RPB members and also coming through on the chat box today. So if anybody else has got questions, please do use the chat box to submit them and we'll get through as many as we can. So I'd like to invite all of the RPB panelists to turn on their microphone and their cameras if they may, and we can start asking you, or should I say grilling you, on all the bits that we want to know now.
I'm sure they'll be kind.
I'm sure they will. So, David, would you like to start on behalf of ICAS, please?
Yeah, certainly. Thank you very much, Carolyn, and thank you to R3 for putting this webinar together and for inviting all the RPBs to join with that. Paul, the question I have from our members is the statement required from the monitor is that it's likely that a moratorium for the company would result in the rescue of the company as a going concern. Likely appears to be quite a high bar to conclude on. And the question, I guess, is why was it decided not to apply the same test that's in Schedule B1 of the 1986 Act to assess the prospects of an objective being achieved in administration, and that test being reasonably likely, which obviously just has a slightly lower bar to achieve?
Yeah, hi David, thanks for that. I think there's a number of things to say about that. I mean, first of all, of course, that test has been relaxed during the COVID-19 period. But I think there are a couple of things. First, we wanted to ensure that the integrity of the moratorium was preserved, and that it not simply be used by companies that had little chance of being rescued, or were just looking for some sort of payment holiday. So we felt that likely was a good test, but we also had in mind, and I can't remember from which court decision it was, that likely actually means more likely than not. And we felt that that was a reasonable way to go forward. And I seem to remember that came out quite well in the consultations that we had with stakeholders.
That's great. Thanks very much, Paul. The next question I'd like to put to you is around the guidance for monitors, which states the monitor is not prevented from taking up a subsequent appointment subject to the insolvency practitioner making an assessment of any threats to compliance with the fundamental principles. The subsequent administrator or liquidator is obviously likely to consider whether the monitor's conclusion that the rescue of the company as a going concern was likely, just as we've discussed there, given that it didn't materialise, as well as, for instance, reviewing the monitor's fees and actions and challenging that if necessary as well. Does the Insolvency Service accept that there is going to be an inherent conflict in every such case?
I think potentially, but I think the onus is on the practitioner. If they consider that there is likely to be a conflict of interest and safeguards can't be applied, then they should not accept the appointment in line with the code of ethics. I guess section A42 does provide some additional safeguards, as directors and creditors can apply to the court after a moratorium is ended if they felt that interests were unfairly harmed. I hope that helps a little bit.
Yeah, I think that's helpful, Paul.
Yeah.
The next question I wanted to ask on behalf of our members, I guess, was the profession has certainly overwhelmingly welcomed the new provisions within the Act, providing useful additions to the toolkit for professionals in the insolvency and restructuring area to utilise, and that's been very public, I guess, in the support that's been for that. Privately, however, I think we're certainly hearing that many have expressed concerns that, particularly in relation to the moratorium, the potential benefits of a 20 business day stay on creditor action and a limited payment holiday for some pre-moratorium liabilities are possibly going to be outweighed by the challenges which a moratorium provides. And by that we mean, there's obviously going to be quite a significant cost around the work that the monitor has to do to make the statement, the ongoing monitoring during the period of the moratorium, cost of bonding, the very fact that it's about the likely rescue of the company itself as a going concern as opposed to necessarily the business. The perception perhaps that this is really just another insolvency procedure, although clearly it's not intended to be that, but just the very fact that it's overseen by an IP governed through the Insolvency Act, etc., etc. All adds to that illusion, if you like. Is the Insolvency Service concerned that the moratorium won't reach the attention of those that it could really be helped, and that it might end up being underutilised?
Well, that's an interesting question. I think we're reasonably confident that it will be used. It's not meant to replace other procedures that are already in the insolvency framework. It's an additional one. You did make a number of references to the various duties to use the moratorium, and I think that's quite interesting. And we have tried to make the moratorium as user-friendly and as easy as possible to use, but there's always a balance to be struck. And that balance it is about ensuring that all of those that are affected by the moratorium, as well as those that it's designed to help, are reasonably satisfied that as a legislative tool, it is fair on all parties. And we need to ensure that that sense of fairness was relayed properly in the legislative construction of the moratorium. If you're going to infringe on contractual rights, you need to ensure that proper checks and balances are in place. And it goes back to, I think, what I said earlier. We wanted to ensure that the moratorium and its integrity was maintained, and that it wasn't seen as simply as a tool for a payment holiday or for companies that shouldn't be there at all. So it is a tough balance to make. But that doesn't mean to say that given another 3 to 4, 6 months of experience of use, that if we find that it's not working in the way that we want it to work, or we feel that some of the checks and balances are too high a threshold, that we won't come back in and make some changes if we need to. It's about monitoring it and keeping a very close eye. But it's very difficult, of course, under the current circumstances. Is the current circumstance normal? Well, no, of course it's not. So it's going to be quite a difficult one to judge over the next 3 to 4 months, and it might be the next 6 to 9 months that we have to make a proper judgment as to any further changes if we need to make them. Is that all right, David?
That's great. Thanks very much for answering that, Paul. Yep.
There was one more thing you asked, and that was about estimates of usage.
Yes.
You must understand, under current circumstances, I've got no idea. However, when we were developing the tools, we did wonder whether, we did think that the most likely will be the same amount of usage in terms of administration. We thought it would be about the same number. But under the current circumstances, we're not sure.
Okay. I think that's an interesting evaluation, and something which I think we'll all look forward to seeing how that pans out in the months
I'm sure
ahead.
you'll be very quick to tell us otherwise.
Absolutely. Thanks, Paul.
Welcome.
Thank you, Alison. I think you've got a couple more questions about the moratorium process for Paul.
Yes.
Hello, Alison.
We were wondering whether. Hi, Paul. We were wondering whether the service has got any expectations as to the frequency with which IPs should be checking that the entity's got a survival prospect once that they've been appointed as monitor.
No, we didn't want to particularly be so prescriptive in law about that, and we felt that that was probably something that could be left to regulation.
Right. Okay. And I guess it also depends what sort of business the monitor's dealing with as well.
Indeed,
to some extent.
indeed. Because if you start being very prescriptive, you have to think of all sorts of situations. Because otherwise, if you miss one out, then it suggests that that's not necessary.
Yeah.
Yeah.
No, thank
Legislation
you.
is very difficult when it comes to that sort of thing. You know, when you start prescripting something, you have to actually think of every situation. Otherwise, it's assumed that it's not regulated.
Great.
And Paul, can I jump in?
Sorry.
Sorry, I said we had a related question there from one of the members who are listening in, and they wanted to know what the consequences might be for the directors and the monitor if the rescue of the company doesn't materialise after entering the moratorium.
Okay, so the test is more likely than not that it will. And I think there it's about judgment. If the monitor makes a claim that the company is more likely, when in actual fact it's clearly there was never any chance that the company could be rescued, the Act does provide the ability for creditors to take action against the monitor and the directors in the court if necessary.
Thank you. I'm sorry, Alison, another question.
Yeah, no, that's fine. Because I mean, you can't have a situation whereby you say in law that the company must be rescuable, because that's just not practical. Alison, where were we?
Hi. Yeah, I think one of the other questions that our members have raised with us was about the bringing the monitor regime into the bonding regime, particularly given that the IP is going to be in control of funds or assets. And also, I think in the guidance that there's a suggestion that the monitor bonds for the value of the assets, and that's very different for what perhaps a supervisor would do in a CVA, where they're bonding for the amount of assets that are coming under their control.
Yeah. I guess really, forgive me if I answer the question in a slightly different way. I guess it's more likely. I guess it's more about why is it necessary for the monitor to be bonded, and what are they bonding for? So I guess a surety bond normally covers the fraud or dishonesty of an IP, either alone or in collusion with another. And although the monitor, we recognise, is not directly in control of fund or assets, they do have the opportunity to act in collusion with another. So, for example, directors of a company cannot complete certain actions, payment of certain moratorium debts, granting of security, disposal of property, that sort of thing, without the monitor's consent. So we acknowledge, I guess, that the risk of fraudulent or dishonest behaviour is lower for a monitor compared to, say, another insolvency appointment. But we have been working very closely with the bond providers to ensure that that's reflected in the premiums charged for a monitor's appointment. And I We'll be very interested to hear from your members of the type of products and prices that they are being offered for bonding, and if that accords with the discussions that we've been having with the bonding providers privately.
Okay. We can certainly feed.
That doesn't mean to say we're going to get on the phone and beat them up, but certainly we've been having some very constructive discussions with them, and they've responded really well.
Thank you.
David, if I can turn to you now, you have a question on behalf of the IPA members.
Yeah, thank you. Hi there, Paul.
Hello there.
Hi. We were asked that there were some amendments put forward in the House of Lords to extend the scope of the moratorium by changing the criteria to include rescuing not just the company, but also part of the business as a going concern. And I was just interested, what are the reasons for rejecting this provision?
Yeah, these were the amendments that were put forward by Lord Lee and himself. I know that he had significant advice from certain financial institutions. We actually thought that the idea was very interesting and was certainly one that we didn't dismiss by any means. And we are actually considering it further, but in slightly slower time. But the policy development that we had in the moratorium, the analysis and the legislation and the way it was drafted was all based on the company. And so to make a last minute change as an amendment with less than 2 weeks to go before the bill became an act, we just didn't have enough time to assess what it really meant from changing or indeed adding from company to business, which could mean anything. It could mean a part of a business, it could mean an asset, what it could mean. And what we really couldn't work out was what effect that had on creditors. You know, if you're a creditor and you have a debt with a company, you know who your debt is with. But if it's part of a business of the company, it's very difficult to extract that and make that work in a legislative way. So we just didn't have enough time to work it through properly. But we haven't dismissed the idea totally because we recognise that what Lord Lee was arguing for was essentially to make it easier for rescue and use of the moratorium. But there was just not enough time to really work it through properly.
All right, thank you. Yeah.
I had a number of conversations with Lord Lee about it actually, and he was an absolute gentleman, as you would expect.
I think you probably had lots and lots of conversations with lots of people leading up to the Act getting rescinded, didn't you?
Yes, we did.
Thank you, David. We've had another question from one of our listeners, and they're saying that they're aware that at least one national firm has told its staff internally not to accept monitor appointments because of the duties at the outset of it being so onerous. Have you given any thoughts as to what you will do if the market as a whole doesn't actually embrace actually being a monitor as it stands? And therefore, whilst companies might want to go into a moratorium, they might not be willing to act as a monitor.
Well, that is something clearly we will look at very carefully. I mean, if lots of companies are not using the moratorium, and the reason is because of the duties, then clearly we would have to look at it very quickly. So yes, the answer would be to that. It would be pointless introducing a tool that wasn't used, and it was the design of the tool that was the issue. So absolutely, of course, we would look at that very closely. But I've heard conflicting reports. Many firms are preparing to, and some firms may not wish to. It can often be a firm choice.
Thank you. One more question from that's been raised by RC members is that the role of the monitor is quite narrowly defined at the moment. Does that mean that you don't really anticipate the monitor getting involved in advising the company in either ongoing trading or rescue or restructuring proposals, or in any way? And what do you think should happen if the monitor does start to act in that broader way?
Yeah, that's an interesting question. I don't think we've been very prescriptive about that on purpose. Of course, most monitors, all monitors will be IPs, and they will mostly be capable of giving advice that's way beyond the role and duties of the monitors. I think that's largely a contracting matter between the prospective monitor and the company. But I think as long as the rules and the regulatory duties of an IP are complied with, we were not intending to be overly prescriptive in the legislation.
Thank you. If I can come back to you, David, on behalf of the IPA.
Yeah, thank you. You mentioned protections earlier. We're just wondering what does the legislation do to prevent acceleration of claims by secured lenders under the new moratorium and rescue provisions, and also the removal of invoice finance and overdraft facilities?
So that's a very interesting question. It was a very difficult issue that we found during the passage of the bill, particularly with certain financial products that we suddenly realized they could accelerate payment terms. That certainly wasn't a policy intention. It arose as an unintended consequence from giving certain financial markets an exemption from the regulations. And once we realized that actually during a moratorium, financial firms could accelerate payment terms and therefore bring about the non-ability of the company to pay those terms, and therefore force the monitor to bring the moratorium to an end solely on the basis that the financial company would know that it would get super priority status, was not a policy outcome that was tolerable at all. So of course we made some urgent amendments to remove that ability to accelerate such payments. So that's what we did. Super priority status, of course, remains. That's important that it remains, because being required to continue to supply during a moratorium, it was only right that super priority status remains for those should the company be unable to pay their bills during the course of the moratorium itself. So we did those amendments. It was quite a revelation.
Thank you.
Interesting. And one of our members has asked, when you were putting the moratorium proposals together, what was in your mind as being the most useful use of the moratorium? So what sort of company, what sort of position were you thinking that actually a moratorium would be really, really well used?
I guess there are many answers to that question, and I don't think there's a best or an obvious example, but perhaps something along the lines of a company whose business is ultimately viable, but that had suffered some form of shock, or maybe the level of debts that it had accrued over a period of time was making the continued running of the business particularly difficult, coming to a crunch period of certain payments, and therefore needed a bit of relief in order to conduct a restructuring of some form. And that's a very simplified version. I don't think you can list every form of scenario on which a moratorium would be useful. There are just too many to list, which is why I think we didn't try to. Is that helpful?
Yeah, I think it is. Thank you. It always helps to have a bit of understanding from the background. David, I think our last moratorium question before we start moving on to some of the other areas of the Act on behalf of ICAS.
Yeah, thanks, Caroline. Paul, the moratorium obviously not only applies to companies, but can be applicable to LLPs. While it appears that a Scottish LLP can be subject to a Part A1 moratorium, we're concerned that there's a bit of a lacuna in the legislation, so a gap in the legislation for its implementation, in that the Act introduces temporary rules for moratoriums by amending the Insolvency Scotland CVA and Administration Rules 2018, but those rules in fact don't apply yet to Scottish LLPs. So as part of those rules coming in, the LLP regulations were specifically taken out. Is the intention of the Insolvency Service to bring forward amendment regulations fairly soon to allow that position to be rectified, so that Scottish LLPs can use the moratorium and that monitors are properly guided into their compliance with them?
So I think there's two answers to that question. Yes, we certainly do intend to bring those regulations forward. But the second part of your question was quickly. We will try and do so as quickly as we can. Now that sounds a bit brash, but just to explain, I think the amount of, because they will be secondary legislation, the amount of secondary legislation that the government needs to bring forward in the next 6 months is extraordinary. Not just business as usual, but business as usual, I think, is about 4 ranks below what's above it. So there's an extraordinary amount of legislation that needs to be brought in for emergency COVID-19 related. Then there is the finishing off of Brexit regulation, which is still not completed, because it's still not clear whether we will leave with with some form of a deal or maybe no deal. And then finally, there is a significant amount of legislation needed, not only for government manifesto commitments, but for anything that's trade agreement related, where trade agreements are already being negotiated. You could probably hazard a guess as where this one would fall in that queue.
Yeah, certainly, Carl, in terms of that queue, but I understood that in terms of the Act, sufficient powers had been taken, and I think you referenced it earlier on, that sufficient powers had been taken to enable serious deficiencies to be rectified quickly. This appears to be a serious deficiency in terms of it could potentially affect a lot of Scottish LLPs, which are, particularly, I would suggest amongst the legal sector, where this moratorium, if it was necessary, could actually be really beneficial in that situation. So perhaps just ask for the service to reflect on that, perhaps.
And I'll try and bring those arguments to the House authorities to try and get the time I need.
Thank you.
But completely get it. Completely get it.
Thanks, Paul.
David, I think you've got another question moving on to the rescue procedure on behalf of the IPA.
Yeah, thank you. We just wanted to ask what the thinking is behind the inclusion of financial services companies being able to use the new corporate rescue procedure, but obviously giving the Secretary.
Sorry, David, you've gone a bit hazy. Could you? I missed some of your question.
Right. Okay. I thought I was doing so well. Yeah, it was about what the thinking was behind the inclusion of financial services companies being able to use a new corporate rescue procedure, but giving obviously the Secretary of State power to exclude them as well.
Okay, so forgive me if I answer that question in a slightly different way, because it seems to me, because I've had this question quite a lot, why were there so many exemptions given to financial markets from not just the moratorium, but other parts of the rescue procedures? And I think the overriding answer to that question relates to the fact that a greater duty is placed on those financial companies through financial stability regulations, and those regulations that came out of the financial crash from 2008, 2009. My colleagues from the Treasury and the Financial Conduct Authority, the FCA, were quite insistent that these exemptions were made on the basis of the requirements that they had, that the restructuring tools should not impede in any way or override their own regulations relating to the maintaining of financial stability. Now, there'll be different reasons for each different exemption and each different area. Far too many to go through, but that's the general overriding reason. And I must say that since the passing of the Act, I continue to get representations from markets I've never heard of that also insist that they need an exemption of some kind. And I think it just reminds us of just how pervasive and overarching insolvency law is on the whole economy. But that was the overriding reason.
Right, I mean, thank you. I appreciate it.
The last one I had was in relation to liens for cargo and haulage industry. But it goes on and on and on, I'm afraid.
Yeah, thanks. I appreciate that. It's a big balancing act, isn't it? So.
Yes, yes.
Paul, we've got a question from another delegate. Is it envisaged that the new Companies Act restructuring process will be practical and cost effective for anything other than large or very large companies?
The restructuring plan. Well, we haven't prescribed that it should be used by only one size of company, but we do recognise that it's most likely to be used by larger companies with much more complex debt arrangements because of the I think the type of restructuring and legal sort of arrangements that are needed to not only construct a plan but get it through the voting systems and the court sanctioning. So we would find it, whilst we would be highly delighted to see smaller companies use a restructuring plan, we wouldn't necessarily expect it.
Thank you. And another one from our members is, please can you clarify what sanctions or penalties exist for creditors who terminate contracts and refuse to supply? That's in relation to the protection of supplies rules. Yeah,
that's an interesting question. I would like to get back on that one. There are, but if you don't mind, can I get back on that question? Could you email that to me?
Yeah, I will do, definitely. Definitely. Nolene, I know that you've got a question you want to ask on behalf of Chartered Accountants Ireland.
Yes, thanks, Caroline. Hi, Paul.
Hello.
We've covered up all the questions already, so I have a general question for you. The government has indicated that it will continue to consider what else it may need to do to support otherwise viable businesses through this current emergency. I mean, what other measures are proposed at this time? And are there any further financial supports planned for businesses?
What a fascinating question. And I'm trying to think of a really polite way to say, you can't expect me to answer that question. Mostly because if there was a new financial grant or a new financial support mechanism, it would be the Chancellor who would announce it rather than me. But What I can say is that I think virtually half of Whitehall is working on this whole COVID-19 response programme. The government is constantly getting representations from absolutely everybody and anybody you can think of, and we are having to take and consider all of these issues on an immediate basis, and constant work is ongoing and never stopping as to what more the government needs to do. But I think also government is also trying to, I'm going to be very careful how I say this, government is also trying to work out, when does the pandemic end? When do we move on? When do we stop the certain measures that are in place? And when does a terrible economic situation just becomes a bad one? And then we start to move on again. All of those things are being considered, but decisions are way above my pay grade. But all of that is being considered at this time. I hope that's helpful.
Yes, well, I think it was a difficult question. Thank you.
Yeah, I'm sorry I couldn't be more specific. But you could imagine, had I announced something, I'd be in trouble.
Yeah.
Thank you. I'm conscious of time, but Paul, if I can ask you just one more question in our last couple of minutes from one of our delegates. And obviously one of the main purposes of the new legislation is clearly to encourage directors to act early, not stick their head in the sand until it's too late. And obviously we've done a lot, you've done a lot of work with the profession to make sure all of the IPs and solicitors are aware of the new Act. But I'm not sure how far the existence and purpose of these new measures have reached the wider business community. Have you got plans to encourage directors and to do a publicity campaign within the business community about what the new measures are, and to get them to encourage directors to get early advice?
The answer to that is yes, but they're not. They've not yet got to the end, and they're ongoing. And I think it largely depends on us actually trying to get out there. And it's a bit difficult to get out there at the moment. But the answer to that question is yes.
Good.
Although I keep saying that we do rely on trade associations greatly, and thank goodness R3 does what it does.
Thank you. Thank you. Well, that seems a very good point on which to end this session. I'd like to give a really huge thank you to Paul, and also to all of my colleagues at the RPBs for coming along and representing your members today. And thank you also to Veronica and the team at R3 for running this webinar.